Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Bruce Boyden, Associate Professor of Law at Marquette University Law School. We will discuss his article, Daly v. Palmer, or The Melodramatic Origins of the Ordinary Observer, which was published in the Syracuse Law Review. So welcome to the podcast, Bruce.
Thanks, Brian. I'm really excited to be here.
Yeah, so as you know, I love this article, and I love the fact that it was part of one of my favorite law review symposia organized by Shubha Ghosh and V. Rosen on forgotten intellectual property. And I think Daly v. Palmer is an especially interesting case in that context because it's like both forgotten and not forgotten at the same time. So maybe you could start by just kind of reminding listeners or telling listeners maybe, sorry, who aren't familiar with the case, sort of what was going on and why you saw it as a forgotten case.
Yeah, so Daly versus Palmer is this case from 1869, decided in the federal district court in New York. And one of the first cases really to decide a claim of infringement, not involving sort of a literal reproduction of some sort of printed work, it was seen as important as in its time, but and it became cited a lot. So one reason why I considered it a forgotten case is because after it was decided for several decades thereafter, particularly in the beginning of the 20th century, Daly versus Palmer was just cited all the time as providing the standard for what counts as copyrightable material that someone else is obligated not to infringe upon, and then how do you tell whether infringement has occurred? And it's cited throughout the treatises and the court cases, particularly by the Second Circuit Court of Appeals, all the way up until basically Arnstein. Arnstein versus Porter in 1946. So, and then the citations just die off basically. So I wasn't aware of this, but when I did the research for this article, I found that the citations go up through the 1930s to Daly versus Palmer into the 40s, and then Arnstein versus Porter is decided. And then basically it's not cited again by the Second Circuit at all, and not by any federal court after about 1947, up until just a couple of years ago when it was cited in a Ninth Circuit decision. So that qualifies it as a forgotten case. I think it was just this key citation, and then all of a sudden dropped to nothing after 1946. It's still cited regularly in the law review literature. And in the Nimmer copyright treatise, typically as being the origin of the ordinary observer or audience test for substantial similarity. So it's had this life in the law review literature that's lived past its citation in the courts, but that's why I treated it as a forgotten case. Is because it was this key citation and then disappeared, and also. I don't know how long you want me to spin this out, but also one thing that really intrigued me about this case that made me want to dive into it for this symposium. I only had very sort of loose awareness of what it was about when I first started writing this piece. And when I first heard about it, it just seemed like an insane decision. And so not only was it this thing that was cited a lot and then not cited after several decades, but it seemed unbelievable to me that this was a key case for so many decades. Given the holding just seems unbelievable to a modern copyright lawyer, which is that Daly, Augustin Daly, the theater owner, is basically suing rival theater owners for producing a play that infringes upon it contains a version of a scene in his play that he says is copying from his play and infringing. And the scene in question is a key scene in his play where a character is apprehended. This is a melodrama. A character is apprehended by the main villain in the piece, the Snidely Whiplash person, and tied to some train tracks. And a locomotive is coming down the tracks and is certain to run over this person. And finally, the heroine actually breaks out of a shed where she's locked herself and rescues him at the last second, right? So this last minute rescue of a person tied to the train tracks. Which is, it's like the archetypal example of a scene from a melodrama. I mean, it's so cliched, at least by the 20th century, that it's used at the beginning of Dudley Do Right, to sort of make fun of the whole idea. And so the idea that Augustin Daly could basically shut down this Dudley Do Right scene from being repeated by anybody else, when none of the dialogue was actually copied by this other production. So this other production just had a similar scene in it where somebody is lying across some tracks where they've been placed by the villain. They're not even tied to the tracks. They're unconscious. So they're lying across the tracks, and another character has to break out of where they're trapped and rescue them at the last minute. And the court said that was infringing on the scene in the earlier play. And I was like, that's ridiculous.
That's bonkers.
Yeah, it's bonkers. And it's an indication, I think the view among copyright scholars, at least, is this view of, the long-term story of copyright law and its development is one of declension. There was a promised land, a very limited copyright at one time, and we sort of been moving away from that ever since. But the idea that this was, not only was this case decided in this way, but it was a key, citation for 70 years, I think indicates that it's a more complex story than that. I think there's no way a court today would say, look, there's this car chase in this movie, and it's even though it's filmed completely differently with different characters, your car chase nevertheless looks awful. It's down the streets of San Francisco or something, right? So it's basically
you're getting there on the hills,
Yeah, exactly, right. You're getting there on the hills, just like they did in Bullitt, right? So the copyright owners in Bullitt, the Steve McQueen film, decide to sue because you're racing down the same hills, right? And you have a car crash at the end, and a court says that's infringing. No way. I mean, that's idea expression dichotomy. So there's no way a court would say that that's protected expression versus idea. But for basically 70 years, this citation was out there saying, nope, that's within the original playwright's copyright.
Yeah. I mean, what really got me about the piece was the way it really illustrates how copyright has always been about competition law. And the question is like, what are the grounds over which people are competing? And in some cases, like historically, like the nature of competition is just like in works of authorship is just over things that look just so generic to us today. But I can't help but think of like the way people today, like, I mean, I just saw an article yesterday where like memers were complaining about like people copying their memes, right? And it totally reminds me of exactly the same phenomenon that you're talking about in Daly v. Palmer.
Yeah, it's a little bit difficult to dial back the clock and sort of picture this case as it appeared to the judge in 1869, because even though we view the character tied to the train tracks as a sort of a cliche today, Augustin Daly was basically the first person to come up with this scene, and not only. And you mentioned competition law, right? So this is not mentioned in the opinion, the importance of this scene, but I can't imagine Judge Blatchford, who later went on to sit on the Supreme Court. So he's the district court judge who wrote this opinion. And he's the only federal district court judge in New York at the time. I can't imagine that he was unaware that this was not just any scene in the play. So this is another thing that I found out through the research. I was unaware. So Augustin Daly writes this play. This play is a melodrama, And melodramas are becoming a preeminent genre in about the 1850s and 60s. And in particular, this style of melodrama called the sensation melodrama is the one that Daly is writing in, and competitors of his, such as Dion Boucicault, who is actually the author of the play that allegedly infringed on his. So they're all writing these things called sensation melodramas. Melodramas look particularly ridiculous to us today because they're these stark conflicts between good and evil, and all these ludicrous coincidences happen to the main characters, and they prevail through them by force of their virtue as characters. We sort of demand more realistic characters today. But at the time, that was particularly that was particularly interesting to audiences who were very uncertain about their place. Just one wrong step at the factory, and basically your family starves to death.
I mean, there's almost like a Pilgrim's Progress sort of quality to it.
To the melodrama, yeah. And particularly for the sensation melodrama, the particularly subgenre that Daly was writing in. The sensation melodrama, for its appeal to audiences, relied particularly on the sensation scene, which was always placed in the penultimate act. So it's in Daly's play, it's Act 4 of a 5-act play. And the sensation scene was basically the equivalent of a special effects bonanza, right? So it was some scene on the stage that required incredible showmanship and a lot of work in setting up the scenery on the stage to get this to pay off, that audiences would not be expecting to see on a stage, and so
or maybe would be expecting, and that's why they came in the first place. I mean, in a weird way, that aspect of it seems so contemporary.
Right. It's what drew them in, right? So it's the equivalent of the advertisements you see. I mean, these are basically the Hollywood blockbuster films of their time, right? So it's the equivalent of the ads that you sometimes see for Hollywood movies. You've just got to see this on the big screen, right? So you've just got to see how Daly's new play shows somebody almost getting run over by a train, right? Or other plays had like fires. There's actually another play that Daly wrote that had a character tied to a plank in a sawmill, right? And who was rescued at the last minute, sort of Goldfinger style. And so this is the key thing, right? So this sensation scene, the making of the train that actually appears on the stage, that's got it's a prop being with a bunch of stagehands underneath it. But the appearance of that train on the stage, nearly hitting one of the characters, was like the key moment. It was like the key draw for the whole play. And so that's what Dion Boucicault took. He apparently saw a production of this play in London in 1868. And he basically said, there's not much doubt that he was, he said, my next play has got to have a scene like this. And so he did. So Boucicault put in his next play, which was another melodrama, the plot of which was, basically completely different. But in the penultimate act for his sensation scene, he put in a scene in which a character is knocked unconscious in the London Underground. So the London Underground had just opened like 5 years before he wrote this play. And the character's knocked unconscious and left across tracks in the London Underground. And another character has to break out of where they've been locked in to rescue this unconscious person at the last second. So he puts that in. And so this is not just any old scene that Boucicault has copied. It's like the preeminent draw for the whole movie. Or sorry, not the movie, the play. The preeminent draw for the whole play. And I have to think that Judge Blatchford was aware of that. And so when he says that, that the defendants are liable for infringement here because they've copied all of the action of this particular scene, I think it's got to be part of that it's not just copying the action of a particular scene, but copying the action of a particular scene where the action is particularly important to the overall economic value of the entire play.
So maybe you could talk a little bit about what you think it meant in the moment it was decided, sort of how the meaning of the case changed over time and why it became a forgotten case. Like, why did Arnstein become like the kind of replacement reference for the same concept,
So
right?
so that's a really interesting question. So and that was what most surprised me about when I dived into this. So I knew that Daly had been there and it was cited a lot and then forgotten. So I figured I just traced the history of that, and I figured it just died away from old age, basically. But that is not what happened to Daly. First of all, for about 30 years after it was decided, even though it's now come to be seen as this departure moment, where the copyright right sort of shifted from being about rights of reprinting a physical object to more of an intangible property right, it didn't initially have wider significance beyond plays. So Daly's initial significance in the late 19th century, from 1869 up to about 1903, was seen as just, hey, this is a case that's useful for talking about what's the scope of copyright in a dramatic work. And so if you read the Blatchford opinion in Daly versus Palmer, probably one of the key factors for why this became such an important and cited case is because Blatchford spent a lot of time writing his opinion. 11 pages is pretty long opinion in 1869, and then because he's also the case reporter for the federal courts in New York, he just plops his opinion into the reporter verbatim. So this isn't somebody's stenographic notes or something. This is his own written opinion. So he writes this opinion, and the key thing he's struggling with in that opinion is, what's the scope of Daly's copyright in his play? Is it just the words in the script, the dialogue and the specific wording of the stage directions, or is it how the play is actually performed on the stage? Does that comprise part of the copyright that he has in his play? And he basically reaches the conclusion that it's the latter, that his copyright goes beyond just what's the words that are in the script. It actually incorporates the play as performed on the stage, and the actions that are carried out in response to the dialogue and the stage directions in the script are within the scope of the copyright. So that when Boucicault's play copies those actions, person on tracks, train coming, person breaks out, rescues them at the last second, train runs over that spot, right? That is copying something copyrightable. So most of the opinion is trying to figure out, well, what's copyrightable in Daly's play? And there's actually very little time spent on, well, has Boucicault taken what's copyrightable? There's like a long paragraph where Blatchford just spells out, he goes sort of action by action and says, yep, you got exactly the same sequence of events in Boucicault's play that you had in Daly's play. But most of this is about what's covered by the copyright. And that is the citation to Daly for the rest of the 19th century is for that. What's within the scope of a copyright in a dramatic work. There's a later case in which, and the courts, they say, okay, it goes beyond the mere words, but at least initially they're not really expanding Daly versus Palmer very far, even though they're citing it a lot. So there's a later case in which somebody tries to argue that a special effect, basically a water tank simulating a river on the stage, should be within the scope of the copyright. And the courts say, no, because that, it's just a tank on a stage. It's not telling any story, right? You're using it in the story, but there's no copying the sequence of events from this earlier play that used a tank on a stage. So that's not held to be infringing. And I think there's a case involving a dancer. So somebody dances out or does a series of dances. And they say, well, that's not infringing on somebody else's dances because you're not telling a story with your dances. And so you're not carrying out a sequence of events to tell a story, which is what a dramatic work does. So it's initially not given a lot of expansive view. Where things change is in the 20th century, when the courts start getting all of these cases that are coming up as a result of the boom in mass popular culture that happened sort of starting in the late 19th century, the 1890s or so. So production of sheet music for player pianos, and people are writing plays that are circulating all over the United States, and movies are being filmed, and they're looking for stories to tell in the movies, and so naturally they gravitate towards existing short stories and plays. Um, and plays are copying from other plays, and plays are copying from short stories, and movies are copying from short stories. So you got all this activity going on in the early 20th century, and the question is, well, when you tell a story that's, you film a movie and it's very similar to a Jack London short story, but it uses different names for the characters and doesn't have any of the same dialogue, is that infringing or not? And the courts have to decide these cases, and they looked at Daly versus Palmer for guidance on this, because even apart from talking about the scope of dramatic works, they looked at Daly versus Palmer, particularly for the silent film cases. But silent film cases, right? So it's all action, and very little dialogue. But even for plays copying from plays, they're like trying to figure out, well, have you taken basically the plot from this earlier play? And so they use Blatchford's method of analysis from Daly versus Palmer to say, yeah, you're infringing, even if you took none of the dialogue or script from the earlier play or short story or whatever it was, if you have the same sequence of events. So if you copy, thing 1 happened, and then thing 2 happened, and then thing 3 happened, you copy enough of that, and you're infringing. And so they're citing Daly versus Palmer a lot for that. And in response to that development, lawyers start coming forward in the early 20th century trying to prove infringement, or trying to disprove infringement, by trying to prove how many of the events are similar or not similar. And so they're coming into court, and they're coming into court in equity, I should say. So they're not trying these cases before juries. These are all cases in equity because they're trying to get an injunction. And this is prior to the merger of law and equity. So they're not trying these cases before a jury. They're coming into court in equity and saying to the judge, look, I've got this long, detailed synopsis, and I'm going to bring in, expert witnesses to say that this, kind of play has never been done before, so it's original. And furthermore, the defendant's play does all of these similar events, has all these similar events in the same sequence in it. And the defendants come in with their people and their experts, and they say, no, there's all these events that are different, right? So the record in these cases starts getting really large. And that's the key thing that Daly's getting cited for, is that's the way you do an analysis to figure out if the defendant has taken too much from the plaintiff's work. Meanwhile, some judges getting very frustrated with that. Learned hand, actually, in the Nichols case. We read the Nichols case all the time. There's this line at the end that we typically pass over in teaching the case in copyright law, where he says, the size of the record before the district court is just too huge, and it's due primarily to the use of experts. And what he's talking about is the district court judge in that case had a month-long hearing about.
Oh God, really?
Yeah, a month. It's actually Jessica Littman wrote an article about silent film cases, and she spends a lot of time describing what happened in the trial, or the proceedings in equity in Nichols. And yeah, it was like a month's worth of hearings basically on whether Nichols' play was original. So had her basically plot been done before, and it's almost like patent novelty the way they were doing it, and second, how much of her sequence of events had been taken by the defendants in their silent film. And Hand looks at that and says, this can't be the way we're supposed to decide this question of infringement. It's got to be a more intuitive test than that. It's got to be something where you're asking about the overall impression that a play makes. And so there's this series of decisions starting basically in the late teens that are sort of ride alongside the courts that are looking at sequence of events. And these decisions say that, actually you should step back and consider the forest and not just look at the trees. and ask whether the overall sort of plot of the two works is similar in a way that the observer of a play or movie would appreciate the similarities. And so that test starts developing in sort of tension with also looking at the sequence of events. And so what kills off Daly as a site? It's Arnstein versus Porter. But one thing I didn't realize about Arnstein versus Porter is that Arnstein versus Porter is reconciling these two threads in the case law.
Mm.
And so if you read the full Arnstein versus Porter, you see this dissent from Charles Clark, who is, one thing he says in that dissent is, the two-step process that we're all familiar with for deciding infringement in a copying case, actual copying plus what's now called substantial similarity, or improper copying. Judge Frank, for the majority, says, well, that's the test, right? This two-part test. Clark looks back at the case law. He says, I don't see anybody doing a two-part test in the prior cases. And, I for a long time, I thought maybe he was just wrong about that. But no, he's right. There is not.
That is deep, man.
I was actually surprised to find this. I thought I was just going to write the part of this paper where, Daly's cited for a while and then it dies. But no, something really interesting happens here where Frank says, there's this two-part test, and he's pulling together these separate strands of cases. The sequence of events, test from Daly versus Palmer, that winds up becoming the test for actual copying that Frank uses. And so he says, you look to see if there's any, actual copying of copyrightable material from the plaintiff's work. Although if you're only looking at it to figure out if there's actual copying, not whether it's infringing, you don't need to look at the entire sequence of events anymore. Just once you find some copying of some copyrightable material, you're done. So Daly versus Palmer winds up being step one of this two-part test. And then this other idea that had been developing that, you got to consider how the overall work appears to the ordinary observer or the average playgoer or average listener of music, that which was kind of a reaction to the Daly sequence of events test, that winds up becoming part two of the test. And so that's what Frank is doing. He's trying to combine these things together into one test, and that's what kills off Daly. Once you have that, you cite Arnstein for the test for infringement, and you don't need Daly anymore.
Yeah. Well, that's really the thing that got me about your paper and the sort of perspective you bring on what it meant in the doctrinal history of kind of the way we understand the ontology of copyright is, like, in a weird way, I feel like Daly v. Palmer is almost like the Lochner v. New York of copyright law. I mean, it's like it was a case that like was kind of weirdly decided on the facts that then became the basis for an entirely new way of thinking about the subject matter of an area of law that really had nothing to do with what the actual case was sort of grappling with in some ways.
Yeah. I mean, you sort of feel for the judges in the early 20th century, though, because, I mean, they have to decide these kinds of cases that haven't come up before. I mean, one thing that I found when I looked at Daly was, Judge Blatchford has this problem trying to decide this case of what's within the scope of the dramatic copyright, which is that when it comes time to figure out if a non-literal reproduction of like the action of a play infringes, right, and how close does the alleged infringing work have to come to the plaintiff's work to be infringing? What counts as similar enough? The case law that he's looking at in 1869, prior cases on infringement, there had been plenty of cases up to that point that considered something less than complete reproduction of the plaintiff's work and whether that was infringing. But the vast majority of those cases concerned informational works, math textbooks and grammar textbooks and books about how to get bills passed in Parliament, George Washington's letters, et cetera, right? So not works of fiction or works of art where you're talking about what is the like aesthetic value of the work to its audience that's willing to pay for it. With informational works, it's have you sort of reproduced the work or the efforts of the original author in sort of organizing it in a particular way that makes sense to people? Have you duplicated enough of their organization of these materials or presentation of these materials to sort of cut into the profits that the original author is getting from how they arrange things? It's kind of a different question from have you taken the draw of a fictional work that's pulling in people and making them pay to see the play or buy the novel or whatever it is.
Well, and that's what really gets me about it is it seems like initially it was like just nakedly a question of, are you competing? Mm-hmm. Like, I mean, are you competing in a way that we think that the author of the original work is entitled to object to? And then in the 20th century, it became not about like just are you competing, but it became a kind of laden question of like, are you competing in like the wrong way? Have you taken something you're not entitled to take? Right. And there was something much more like kind of, like when it was initially decided, it was much more naked in terms of what the question being asked was. And then it became kind of like normativized in the 20th century in a weird way.
Yeah, I think what's going on is that the notion of what's the market for a work is changing. And I think that's changing because of overall changes in the economy, not just for cultural goods, but overall in the economy, manufacturing and services and the like, they're all moving from sort of very local productions to more regional or national productions. On you've got the Industrial Revolution, you've got things that standardized parts and fast transportation that can get things all over the country. And so this is affecting, I think, arts and culture as much as it's affecting, widgets and articles of manufacture. And Daly's suit, I think, is probably motivated by some of those early developments, even in 1869. Because one thing that's happening to Daly is that Daly is trying to run a theater with a stock company in 1869, when many other theaters have moved away from that model. And in fact, in the economic crash of 1873, basically the number of stock companies in the country goes down from 50 to 7. So he's one of only 7 left. Other companies are producing plays, and they're circulating the plays around like the Eastern Seaboard, relying on trains and other, and also improved methods of communication to get the word out. And Daly's basically stuck with his stock company in New York. And the company travels a little bit, but in order to make money that competes on the scale of the traveling companies, he has to license his production to other companies to produce. And I think that must have been a driver behind his suit. I mean, he's also just an irascible person who gets in fights with people all the time. Daly actually once sued a newspaper publisher for, you'll appreciate this, Brian. He sued a newspaper publisher in New York at one point for accusing him of plagiarism. But the basis for his defamation claim was not that he hadn't committed plagiarism. It's that the newspaper article accused him of plagiarizing the wrong play. So anyway, so he's likely to sue at the drop of a hat, but he also has an economic motive for it, and that sort of thing I think just increases, right? So I think in 1869, right, who is he suing? He's suing a rival play producer. He's actually suing. He doesn't sue Boucicault directly. He sues the theater in New York that's going to host this rival play. And so that's his competition, right? People who are producing a version that he says is at least contains the same scene from his play. By the 1900s, I mean, like I said, you've got this explosion in culture in all different forms that are being sold to consumers in some way. And producers are looking for material in lots of different forms. And so they're buying and licensing the rights to produce plays and, from short stories or from other plays or movies. Like in Nichols versus Universal Pictures, Universal tried to license the right to make a version of Abby's Irish Rose. And the negotiations fell through. So they're like, okay, fine, we'll make the Coens and the Kellys then. And so I think the notion of what's the market for the work goes beyond just, if you've got a play, it's producing plays. It goes to, if you've got a play, you can make money off of your play. You can make money off of a movie version of your play. You can make money off of a short story version of your play. And so I think that's and so the judge is trying to decide, well, how much of that is the original copyright owner entitled to? When these cases first start coming up in the early 1900s, they don't have a lot of case law other than Daly versus Palmer about what might define the scope of somebody's rights in other media. And so that's, I think, why they start looking at Daly versus Palmer for just some sort of guide. And Daly says, well, you look at the sequence of events, right? I mean, you can look at the dialogue if it's copied, but if not, you look at the sequence of events. So that way you can tell whether this silent film infringes on the copyright in this play. Is it telling the same story as the play? So I think that's completely understandable. It just turns out not to be very workable. There's some cases I talk about in the article where, there's one short story that was turned into a play, I think, where basically it seems like just the outlines of the short story were taken by the play. Court holds that infringing. Second Circuit. Like 2 years later, somebody else tries to do a silent film of a Jack London short story. Sounds pretty close to me, maybe even closer than the earlier case. But the court says, no, the idea of two thieves, poisoning each other so that they can get the loot, it goes all the way back to Chaucer. So, you can't get a copyright in that. It's just very ad hoc, basically.
Yeah. Well, so Bruce, I'm wondering, like, in closing, can you reflect on what sort of researching and thinking about the real history of Daly v. Palmer can tell us about, or like what you learned about, like thinking about copyright history and understanding copyright history in context?
Yeah. So, this paper wound up becoming part of a project that I've been engaged in for a while now, where I'm looking at the state of our copyright doctrines today, particularly the older ones, and I'm trying to figure out how they got into that shape. And I started off this series of inquiries by thinking, you've got the test for infringement, and it's got two parts to it, at least the way the Second Circuit does. And the Ninth Circuit's got a different two parts. Where did that come from? What were the courts that came up with that originally trying to do? Maybe we can shed some light on what is troubling current courts about, how to determine whether something's substantially similar to something else. Maybe we can shed some light on how to do that by going back to the original goals of the test and figuring out what courts were trying to do. And then maybe we just need to update their goals in a different way for modern times. So I've been kind of doing that. And the problem I've been running into is in a lot of cases, the factors of the test that have been passed down to us today are just completely arbitrary. They're just like historical accidents, basically. And so I think Daly versus Palmer kind of indicates that for the test for infringement, right? So when the the question comes up before the Second Circuit in Arnstein versus Porter, how do you do the test for infringement? They've got two lines of cases, and those wind up becoming the two parts. But there's not really much that informs how you do the second part, right? So you figure out whether there's been actual copying, but then how do you figure out whether that level of copying is improper? The court's always really vague on that, and it's vague on that because that line of cases basically is a response to Daly versus Palmer, but doesn't really have much content to it, and that's continued to trouble the courts down to today. And you want to talk about historical accidents? I got to get this point in, which is that one of the things I found doing this project is, where did the Ninth Circuit test come from? Where in the world did the Ninth Circuit come up with the idea in Sid Marty Croft versus McDonald's in 1977 that the way you do the infringement test is not by looking for actual copying. You do it by looking for access to the plaintiff's work by the defendant, and then two forms of substantial similarity, the intrinsic test and the extrinsic test. Where in the world did they come up with that? Well, they came up with that from Melville Nimmer. Melville Nimmer was the counsel for Sid Marty Croft, who argued the case in the Ninth Circuit. And that's what Melville Nimmer had written in his treatise for how to do the test for infringement. Where did Nimmer get that idea that that's the test? He got that idea that that's the test from a Second Circuit case decided in 1938, where Judge Martin Manton, who had never been a fan of the Daly sequence of events test, but also apparently wasn't really a fan of the at least the way that Judge Learned Hand was doing the ordinary observer kind of test. He just goes off on this rant in this 1938 case, Shipman versus RKO Pictures, where he's like, the Second Circuit has been doing the test for infringement all wrong for 70 years. It's all due to Daly versus Palmer. That's where things went awry. And then he actually, even though Learned Hand is on the panel, he then says, furthermore, we came up with this idea in Nichols where you're supposed to look at levels of abstraction. What the heck is that? Nobody knows what that means. So no wonder it hasn't been adopted by anybody else. And Hand kind of writes this very, I don't know, you can sense the tension, I think, in this concurrence where he says, well, I agree with the result in the opinion, but I don't agree with all that has been said. Anyway, so Manton goes off on this rant where he says, look, I've got a new test. You look to see if the defendant had access to the plaintiff's material. And then if the level of similarity is enough to indicate copying, then you figure out whether it's enough to be improper. That's our test. And that is so close to what Nimmer says is what Arnstein versus Porter means when he writes his treatise in 1963. Then I think he must have been basically pulling his test from Manton's description of what the test should be in RKO Pictures. Well, I mean, one of the, it's just another interesting footnote there is, so Manton goes on this rant in December of 1938 and writes this opinion. In January of 1939, he has to resign from the court because he's about to be indicted for bribery. So this is his mic drop, right? It's like that flight attendant, right, who got really annoyed with his job, and on the way out he like opened the emergency slide and and left the plane, right? So this is Manton's like, a pox on all of you. You've been doing substantial similarity wrong all this time. I'm out of here. But Nimmer picks that up in his treatise. And that's where the Ninth Circuit test for infringement comes from. So anyway, the bottom line here is, what can we learn? I think we can learn that maybe it's worth revisiting the way in which some of these tests have come about, and not to assume that we need to keep them in the form that they've been used, even though they've been used now for decades. That there's not necessarily a patina of well-reasonedness to these tests just from the fact that they were adopted in the 1940s, 50s, and 60s.
Yeah. Well, thanks, Bruce. I mean, this is like a great conversation. I love the paper, and it was just so illuminating to see like how the context informs what this sort of not only the history of copyright law and copyright doctrine, but also like the history of this like really seminal case that I think, you know, we sort of don't understand how it informs the way that we think about these questions today.
Well, thanks, Brian. It's been a pleasure.
Okay, cool.
I wish I'd never met you, 'cause now I can't stay away, and this feeling is growing stronger, increasing day by day. I have no right to love you. There's another to whom I belong, but I forget her when I'm with you. How can a love that's so right be so wrong? It was just one of those things. It grew from a casual affair. Then it got too big for both of us. Now the damage is beyond repair. I could break the chains that bind me, and I can't escape. It's much too late. How can the love that's so right be so wrong?